Yeah, good morning to one and all. This is Dr. Jayashree, Principal, Soundarya College of Law, Bangalore. Yes, today we will discuss about the provisions of the Industrial Dispute Act of 1947, wherein you have seen in the last class, that is conciliation, then adjudicatory authorities like Labour Court, Industrial Tribunal and National Tribunal. So, there is one more provision for settling the dispute under section 10A of Industrial Dispute Act of 1947, which states that voluntary reference of disputes to arbitration. So, voluntary reference of dispute to the arbitrators. So, the provision, that is section 10A, states that if any dispute or that is any difference of opinion exists or is apprehended, both the employer and the employee can enter into an agreement by writing to refer that industrial dispute to voluntary, that is to arbitration. So, this is a voluntary reference by both the parties in writing to the arbitrators. So, and it has to be signed by both the parties. And now what about the appointment? How many arbitrators shall be appointed? So, under this act, they may appoint n number of arbitrators, but in case if they appoint even number of arbitrators, you know you won't get a majority decision. So, there is a clause, in case if they appoint the even number of arbitrators, then they may appoint one more third person who is called as an umpire. So, the decision given by the umpire is final and it is called as an award. So, this is in case if they appoint even number of arbitrators, then there is a provision to appoint a third person who is called as an umpire. And even they may appoint a sole arbitrator also. By an agreement in writing, they may appoint a single arbitrator or a sole arbitrator, and the decision given by that sole arbitrator is binding on both the parties and it is called as an award. So, now next provision is they may refer the dispute to the arbitrator, and in case if some of the workers are not the parties to that arbitration agreement, now the question is whether that award is also binding to the workmen who are not the parties to the dispute. So, here the answer is yes. So, the award is also binding those who are parties to the dispute and those who are not parties to the dispute. So, once the award is given, the award copy has to be sent to the appropriate government, and appropriate government by notification in the official gazette shall publish it. So, it shall come into effect from the date when it is notified in the official gazette. So, award is binding on the parties to the dispute and also those who are not the parties to the dispute. So, and now the question is, what is the content of the award? Is there any form for the award? So, there is no specific form for the award. The content is, it has to be written, that is the agreement has to be written and it has to be signed by all the parties and referred it to the appropriate government. So, this is with regard to voluntary reference of dispute to the arbitrators. Now, coming to the next enactment, that is Industrial Dispute Standing Orders Act of 1946. So, this is a small act which contains few sections, and now this act speaks about the certification of the standing orders. So, now you may ask me a question, what is a standing orders? Standing orders means the rules and regulations which has been framed by the employer before he starts his establishment. So, now he has to frame the rules and regulations or the standing orders in accordance with or in conformity with the model standing orders which has been given in the schedule along with the Industrial Employment Standing Orders Act of 1946. So, there is a schedule along with the enactment, and the employer has to frame his standing orders keeping in mind the model standing orders. Now, what is the process for certification of the standing orders? So, here the employer has to frame the standing orders and submit 5 copies of the standing orders to the certifying officer. So, now the 5 copies are with the certifying officer. Now, the duty of the certifying officer is he has to, once he submitted to the certifying officer, the certifying officer has to give 1 copy to the employer and 1 more copy to the trade union, or in case if there is no trade union, to the representatives of the workmen. So, 5 copies of the that is 5 copies of draft standing orders has to be given to the certifying officer. Certifying officer will give 1 copy to employer and 1 copy to the representatives of the workmen. And the certifying officer may call for an objections. So, once he goes through those standing orders or the rules and regulations, he may ask for the objections by giving a notice, and from the date of submitting the standing orders to the certifying officer, within 15 days he may call for the objections and he may hear those objections, and after hearing those objections he has a power to certify those standing orders. So, now certified standing orders, once they are signed by the certifying officer, he has to enter those certified standing orders in his register, and if anybody wants a copy of those certified standing orders, he may take a prescribed fee from them and give a copy of the certified standing orders. So, now the certifying officer, once he certifies, he has to give a copy of it to the employer as well as to the trade union or to the representatives of the workmen. Now, what is the duty of the employer? So, now the standing orders are in the hands of the employer. So, employer, he has to paste it at the entrance of the establishment, or where the majority of the workmen are entering, there he has to paste it on the wall. And now, what are the, which language or in which manner it has to be pasted? So, here he may paste it on the notice board, or he may even get it typed on the, that is on the paper, and paste it on the wall. And now the language. So, the certified standing orders shall be compulsorily written, shall be in English as well as the vernacular language, that is where the majority of the workmen are speaking. In that language he has to write it and then paste it at the entrance of the establishment. And next one is the certifying, the certified standing orders shall be pasted, and it has to be given, 1 copy also has to be given to the trade union or to the representatives of the trade union. And the certified standing orders, where the certifying officer is doing it, shall be final, and in case if they want to go for the appeal, then there is a provision for that also. So, next question is, after certifying those standing orders, is there a provision for modification? Yes, there is a provision for modification, that is from the date it is certified, from that date within 6 months they cannot modify, they cannot apply for the modification of the standing orders, but subject to the agreement between the employer and the employee. So, these are the provisions of the Industrial Employment Standing Orders Act of 1946, wherein the certifying officer certifies the standing orders. So, overall the standing orders may also contain, for example, classification of workmen, may be temporary, permanent, badly or apprentice, so on and so forth, or it may also state about whether he is appointed on monthly basis or yearly basis, that is his duration, then about the retrenchment, termination, misconduct, unfair practice, or even with regard to his duration, shift wise or attendance, late coming, all that has to be included in the standing orders, which has been stated in the model standing orders. So this is a small enactment wherein they may ask a question in the exam that explain the procedure for certification of the standing orders, or they may ask a short note, write a short note on the modification of the standing orders. So these are the two topics which are covered today, that is, one is voluntary reference of dispute to arbitration, that is under section 10A, whereas the Industrial Employment Standing Orders Act of 1946 about the certification of the standing orders. So with this, let me conclude my lecture. Thank you one and all.